Hello and welcome to the Data Privacy Lawyer. My name is Funmi Owolabi and I am the principal attorney at the firm. Today's review, we're going to be looking at some AI terms. I'm doing a series on the channel. We're going to be looking at artificial intelligence and how it interacts with personal data and how companies are generally discussing how artificial intelligence interacts with personal data, provided whether it's in a customer capacity, consumer capacity, or a different type of data subject, and what types of terms consumers are signing up to and how it interacts with their personal data. So the name of this company is builder.io. Let me see the platform. So here are the products: generate, iterate, and optimize pages and headless content, generate production-ready web apps, and I guess this is user interface, right? Here are the users. So we've already seen that there are going to be individuals in play. The reason I've highlighted users is because users often come with personal data. I've never encountered a system where there's no personal data that is processed in any capacity, whether it's from the users, whether it's from website information that could identify an individual. It's really hard, or if not impossible. I mean, if you've ever seen a system, I would be intrigued. Leave a comment below if you've ever encountered a system that does not interact in some capacity with personal data, but I have not encountered that in my practice. I've highlighted users here because it tells me that there's going to be some type of personal data in scope as it pertains to the products. So it looks like there's going to be engineer teams, design teams, product teams, etc. Let's look at the verbiage in the terms. We can see the date this was last updated. I like this, and I mentioned this a lot on other reviews. If you watched any of my other videos, it's really important to put this date for two reasons. One, if there's any changes to the products, you can identify that in the terms, and two, if there's any changes in the law. There have been several artificial intelligence legislations globally that may impact the products that are provided to customers in different geographies. It's really important for businesses to be cognizant that those AI legislations are important for review if you're going to be asking customers to sign up to specific terms. Let me give you an example. If the AI term says there's certain due diligence that you need to conduct and there's certain technical specification that you need to have about how your AI ingests data and what type of outputs are created, that's something you're going to need to know and be able to relay to your customers in your terms. If you're not aware of those new AI legislations that affect your products and services, one, you could be in jeopardy of being non-compliant with the law, and two, you could be asking a customer to adhere to a specific provision within the terms that actually is not consistent with their privacy practices or even with the laws that have been updated. So in your review of your AI terms, you need to make sure what laws apply to me when this is being updated. Has the law changed since this time? And how am I going to update the terms that are distributed to my customers to reflect changes that affect me and my business? Okay. Builder provides and makes available the AI to customer pursuant to the terms and conditions that apply to the services in this agreement. AI means the artificial technology, whether proprietary to Builder, a third party, or open source. Now, as a customer, from a customer point of view, I would be asking about having the list of third parties associated with the artificial intelligence. The reason that I think that's valuable is because a customer needs to be able to maintain their own privacy compliance. So every company should have its own privacy program. This company probably has its own privacy program. The customer in this instance probably has its own privacy program. When you're reviewing the terms as a customer, you need to be able to understand everywhere that your data could go to, which includes a third party that is in association with your supplier. So you're looking at what is it that your supplier is doing with data and how does it influence my privacy program? Because you're connecting the two. It may be that the customer is not providing all of their personal data to this entity, but they're providing some. And that data is still the responsibility of the customer, irrespective of whether they're providing it to a supplier in order to obtain a license to a platform for Fusion or Publish or whatever. So if there are third parties involved, having a list of that from the customer's perspective is going to be very important. I presume that suppliers are also doing their due diligence if they are going to be liaising with a third party in order to provide their platform. You as a customer should be requesting insights into the types of contractual obligations that are placed on third parties by your suppliers, because it could influence your own ability to maintain compliance. I'll give you an example. Let's say, for instance, you have a privacy program and you need to fulfill something called a data subject access request. Let's say you as a customer, one of your consumers that you provide services to says, hey, I want you to delete all of the data that you have on me. If you've provided that consumer's data to the supplier and the supplier has then subsequently provided it to their subprocessor, you're going to need to make sure that whatever contract has been signed between these two entities, for example, requires this third party to fulfill that data subject access request too. If you only place that restriction or obligation on your supplier, but you don't require your supplier to place it on their subprocessor, you could have a problem with maintaining your own compliance. Now, that's just an example. I don't know what this business is doing, but I find value in giving insight to organizations on some considerations they can have when it comes to these terms. And also what a privacy counsel can provide value in your organization in order for you to be able to understand what are the risks associated with doing business with a supplier and how am I going to maintain my own privacy compliance. If you have a great program, but the contractual obligations with your supplier or subprocessor are not accurate, it could jeopardize your own compliance. Customer may provide or submit customer data. Let me see if there's a definition of what constitutes customer data. The term customer data is defined in section 4.2 of the agreement. I want to highlight this. We're going to go back to this sentence, but I want to highlight this because from a privacy compliance standpoint, a lot of companies are always looking to privacy counsel to exclusively review documents that have the word privacy in them, right? There is an oversight by a lot of organizations about the review that needs to take place with all the agreements and any type of documentation that discusses the products. If the products are processing personal data, there is going to be need to review by a privacy counsel on any legal documentation, even if it doesn't have the word privacy in it. Because you can see here the definition of customer data is in the agreement, but that's not in the AI terms. So you as a customer need to be able to understand what it is you're agreeing to in the terms, even if the definition of customer data exists in a different document. And when you have your privacy counsel review whether or not you should engage a particular supplier, you need to provide every single document because there may be terms in this service agreement that are not outlined in the AI terms. And how the AI interacts with the input data or output data could be influenced by what's listed in the service agreement, even though this isn't a traditional privacy document. It is in my eyes because I'm a privacy counsel and I know that there are definitely provisions that generally exist in SaaS agreements that overlap with privacy that need to be read in addition to all of these. Let's go back to the sentence. Customer may provide or submit customer data to the AI input and receive images. Now, we already know that an image of an individual identifies them. If you've clicked on this video, you've seen my picture in the thumbnail, and I've just stated my name. You're able to identify me, Funmi Owolabi, through my image, so it constitutes personal data. I don't know what image they're referencing here, but I can presume that it may be the image of a person. Now, they've kept it very broad, but from the customer's perspective, you need to take into consideration, am I going to be using this platform and inputting images of individuals? Now, what is my obligation as a customer if that's the case? And what is the obligation of the supplier if they're going to be ingesting images of individuals? In addition to that, we've got other content generated and returned by the AI based on the input output. So if you're importing images of individuals and the content generated includes images of individuals, you need to be looking at the technical specification for this organization and reviewing all of these documents to understand your risk tolerance with respect to what this company's privacy program looks like. How do they treat input data? How do they treat output data? Are they going to help me maintain my own obligations under the privacy laws if images are being processed by their AI? All right, so let's look at one more thing. Let's look at similar outputs. Customer acknowledges and agrees that due to the nature of AI, output may not be unique and the AI may generate the same or similar output for other customers. Customer will not pursue or maintain any claim against builder or any third party arising from or related to any output generated by the AI or the output generated by the AI that is similar to any output. I'm going to highlight this because even though this provision isn't exclusively about privacy, I think there are privacy implications that could ensue based on what is inputted. And I think it's really important for the customer. The reason I've highlighted this is because some of the outputs, this disclaimer is basically saying that this organization may generate output that is distributed between lots of different customers. And why that's important is because of what could be inputted. Now, I don't know which of these is personal data, but there could be ramifications in certain geographies based on the fact that similar outputs can be distributed to several customers. This is why I think it would be valuable for customers not only to review these legal terms, but also to review the technical specification on how this AI functions, right? Because that's not listed in the terms. You don't have every single detail here. And as part of your due diligence, which is a part of your privacy program, you should be asking for, how does the AI work in practice? How did you test it? How did you train it? Etc., etc. And then having your privacy counsel build you a risk profile on engaging with this entity. That's why you need to read the terms, in addition to the internal documentation that are generally only distributed to prospective customers. It's likely that a business is going to have to sign an NDA to have access to that information. That's not something that they're going to place on their public-facing website. But you can obtain that documentation if you're going to be engaging with this organization, and you definitely shouldn't be obtaining that data during the contract negotiation phase. That's something you should be obtaining during the request for proposal phase. So I really hope you enjoyed this review. If you have comments about what I've said, leave a comment below and I'll see you in another review.